Hello viewers, I am Dr. Premchand from National Law University, Delhi. It is my pleasure to welcome you to this session on a not so common topic in the law of property, that is English mortgage. In this session, we would learn about the meaning and significance of the English mortgage. This session would help the viewers to understand the importance of the concept and will able to make out the situation in which the provisions of English mortgage would be attracted and will be able to understand the effect of such an application. Section 58A of the Transfer of Property Act 1882 defines the term mortgage as the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The practice of using property as collateral for borrowing money to satisfy different needs is as old as civilization itself. However, there was a gross inequality between the mortgagor and mortgagee, as the value of the loan was much less than the value of the property mortgaged, and the interest charged was unduly high. Under the Act of 1882, there are 6 different kinds of mortgages. Section 58E deals with a mortgage known as English mortgage. This is a kind of transaction where the mortgagor absolutely transfer the property to the mortgagee with a proviso that he will retransfer it to the mortgagor after the payment of mortgage money. The mortgagee acquires the right to possession as soon as the contract is executed. If the mortgagor fails to pay the money by the due date, the mortgagee can sell property without the permission of the court. Now we will understand the nature and ingredients of English mortgage under section 58E. A mortgage involves transfer of interest in the immovable property for a specific purpose, which in most cases is providing security to the lender for the loan taken. A mortgage may be of different kinds of mortgages according to the specific rights and duties of the parties. The Indian law recognizes 6 kinds of mortgages under the Transfer of Property Act 1882. One of the 6 mortgages is the English mortgage. It is a kind of mortgage where the mortgagor transfers the property completely to the mortgagee with a condition subsequent that it would revert back to him on the payment of the loan amount on or before the specified date. For example, X mortgages his house to Y for a loan of 10 lakh rupees, and he binds himself to repay mortgage money on a certain date and transfers mortgage property absolutely to Y. However, such transfer is subject to this condition that Y will retransfer mortgage property on repayment of mortgage money before agreed date. This is case of English mortgage. To constitute an English mortgage, 3 conditions must be satisfied. There have been reiterated time and again in various judicial decisions. A plain reading of section 58 shows that for a transaction to constitute an English mortgage, the following essential conditions must be satisfied. The mortgagor must bind himself to repay the mortgage money on a certain date. The debtor remains personally liable to pay the debt on a certain date. An option for an early payment or extension of the time period for the repayment is a matter of grace and does not affect the covenant to pay on the specified date. The property mortgaged should be transferred absolutely to the mortgagee. The definition of English mortgage as given under section 58E of the Transfer of Property Act must be read subject to the definition of mortgage in clause A of the same section. Therefore, it cannot be said that English mortgage involves the transfer of an entire estate in the immovable property from the mortgagor to the mortgagee. This is because in a mortgage there can never be an absolute transfer, as there is transfer of a limited interest only for the purpose of securing a debt. Provision for retransfer. Such absolute transfer should be made subject to the proviso that the mortgagee shall reconvey the property to the mortgagor upon payment by him of the mortgage money on the date the mortgagor binds himself to pay the same. Only when all three conditions are satisfied, the mortgage will be an English mortgage. If one of the essentials is missing, it will not be an English mortgage. It is important to remember that before the payment date, the mortgagor has a vested legal interest in the property, and after the due date, he gets the legal right of redemption. In all kinds of mortgages, including an English mortgage, the mortgagor has a duty to repay the money by the due date and the right to claim back whatever interest he had transferred to the mortgagee. This right that the mortgagor has of having back the interest he had transferred to the mortgagee is known as right of redemption. However, if the condition of retransfer is not invoked, the mortgagee is possessed of all rights absolutely in the property. This right of redemption is conferred by section 60 of the Transfer of Property Act 1882. It is a statutory right and subsists so long as the mortgage subsists. This does not imply that the mortgagee does not have any rights. According to section 67, an English mortgagee can file a suit for the sale of the mortgaged property. This is important to note that an English mortgagee does not have the right of foreclosure. As per section 69, a mortgagee or his agent have the power to sell the mortgage property in default of the payment of the mortgage money without the intervention of the court. If the mortgage is an English mortgage and the parties are not Hindus, Muslims or Buddhists, subject to a notice of 3 months. Therefore, an English mortgage is one where the mortgagor transfers the property completely to the mortgagee with a condition subsequent that it would revert back to him on the payment of the loan amount on or before the specified date. In order to constitute an English mortgage, three conditions must be satisfied. Mortgagor must bind himself to repay on the mortgage money on a certain date. Second, the property mortgage should be transferred absolutely to the mortgagee, but the whole of the estate does not pass. Some estate is left in the mortgagor and only an interest is transferred to the mortgagee. The transfer is made subject to the proviso that the mortgagee shall reconvey the property to the mortgagor upon payment by him of the mortgage money. Absolute sale and other mortgages versus English mortgage. The nature of an English mortgage often causes confusion as to its distinction with an absolute sale and other kinds of mortgages. Now, we will discuss the definitions and other aspects which differ with the English mortgage. In case of definition, English mortgage is defined in section 58E, simple mortgage defined under section 58B, mortgage by conditional sale is defined under section 58C, usufructuary mortgage is defined under section 58D and NMLS mortgage has been defined under section 58G. So, the definitional aspect we can see while reading section 58E, mortgagor binds himself personally to repay the debt on a specified date and transfers the property absolutely subject to the condition for transfer upon repayment. In case of simple mortgage, section 58B, mortgagor binds the property for debt repayment but does not deliver possession. Under section 58C, mortgage by conditional sale is ostensible sale with a condition that the buyer shall retransfer upon the repayment or that the sale will become absolute upon default. As per section 58D usufructuary mortgage, where mortgagor delivers possession of the property to the mortgagee who enjoy the income until the debt is discharged, and under section 58G NMLS mortgage, where a mortgage that does not fall under any of the specified categories and may involve a combination of their features. Now, we will consider the transfer of ownership with English mortgage and other kinds of mortgages. In case of transfer of ownership, absolute transfer of ownership subject to reconveyance upon repayment. In under simple mortgage, no transfer of property and ownership, only on a charge on the property. In case of mortgage by conditional sale, a conditional transfer of ownership based on repayment or default. In case of usufructuary mortgage, no transfer of ownership as such happen, only possession is transferred under section 58D. And in case of NMLS mortgage, which varies based on terms of the mortgage itself, possession of property is required to be transferred in certain cases. Like in case of English mortgage, the mortgagor retains the possession unless otherwise agreed. Like in case of simple mortgage, mortgagor retains the possession. But in case of conditional sale, mortgage by conditional sale, mortgagor retains the possession unless default occurs. So, the same in case of usufructuary, we can see the mortgagee gets the possession of property, but in case of anomalous mortgage, it depends on the terms of the contract. Now, we can differentiate in relation to right to foreclosure. Under English mortgage, section 68 gives a right to the mortgagee to sue for foreclosure upon default. Under section 67 itself, in case of simple mortgage, the mortgagee may sue for sale of the mortgage property upon default. Under the same section, which says in case of mortgage by conditional sale, mortgagee can foreclose if conditions are met. So, section 58D, no foreclosure mortgagee recovers debt through income derived from the property in case of usufructuary mortgage. And in case of anomalous mortgage, the mortgagee has a right to foreclose, but it depends on the terms and conditions, often includes foreclosure rights into the deed itself. In case of the right to redeem, where in case of English mortgage under section 58E, which has been provided, and section 60 will read it, mortgagor retains the right to redeem the property upon repayment of the loan and interest. In case of simple mortgage, same as the English mortgage under section 60, and it is the same in case of English mortgage with help of section 60. And section 60 is also applicable in case of usufructuary mortgage as well as anomalous mortgage. So, there is certain other key characteristics which we always remember in relation to the mortgage. Examples of use of different kinds of mortgages, including English mortgage. English mortgage often used in loans where repayment is assured on a fixed date. In case of simple mortgage, used in cases where the mortgagor continues to use the property. and in case of mortgage by conditional sale, suitable for long-term loans with conditional ownership, and in the case of usufructuary mortgage, used when the mortgagee desires income from the property, and in case of anomalous mortgage, we can see and it depends on the circumstances and needs of the parties. It can be seen that an English mortgage has characteristics of an absolute sale, conditional mortgage and usufructuary mortgage. However, there are fundamental differences between these. An English mortgage is different from an absolute sale, as the whole estate does not pass to the mortgagee, only an interest is transferred. Subject to the right of redemption, some estate is left in the mortgagor and only an interest thereon is transferred to the mortgagee. In case of a conditional mortgage, the mortgagor ostensibly subject to the conditions that on default of payment by the due date, the sale shall become absolute. If the payment is made, the sale shall become void, and if the payment were made, the buyer would return the property to the seller. In an English mortgage, the property is absolutely conveyed to the mortgagee subject to the condition of reconveyance on the payment of the money. While in a conditional mortgage, the sale is only ostensible or apparent. In a usufructuary mortgage, that there is no personal liability like the English mortgage and only the possession of property is transferred. Now, we will consider the difference between Indian law and in common law in regard to the English mortgage. In India, English mortgage is one kind of mortgage out of 6 different kinds. However, in United Kingdom, the term English mortgage is used to refer to the usual form of mortgage. This mortgage can be further divided into two categories, one legal and another is equitable mortgages. Under a legal mortgage, legal ownership of the property is transferred to the lender, while equitable mortgage is created where either transaction does not meet the formal requirements of a legal mortgage but is recognized in equity. Initially, an equitable mortgage was not born until the early 17th century. Under the traditional legal mortgage, once the mortgagor failed to pay the money, the estate would be absolutely transferred to the mortgagee. In other words, the legal fee simple vested in the mortgagee. This form was modified a little bit to a situation where the mortgagee was given the right to use the rents and benefits arising out of the property for the satisfaction of his debt without necessarily taking possession. However, equity stepped in because it was argued that a mortgage is not a conveyance of immovable property, but a transaction intended to give security to the mortgagee for the money he lent, and does not mean that the mortgagor should be deprived of his interest in the property merely because he is not able to pay the money by specified date. The present law of mortgage in England is governed by the Law of Property Act 1925. This act was passed to bring both parties to the transaction on an equal footing. It prevented the mortgagee from exercising absolute ownership over the property and also incorporated provisions whereby the mortgagor could redeem his property if he had paid the money even after the specified date of payment. Under the Act, the classification of mortgages remained the same, but there were changes with regard to the rights of parties. A mortgage by legal charge means that the borrower remains the legal owner of the property in question throughout the mortgage loan period. However, the lender retains sufficient rights over the property to be able to enforce foreclosure and repossess the property if the borrower defaults on their mortgage payments. It is a conveyance or assignment of the whole or part of estate of the debtor in real or personal property of which he is the legal owner, or of some legal estate which he has the power to transfer. A legal mortgage can be created in two ways. One, mortgage by way of demise. The mortgagor must execute demise for a term of absolute years, known as mortgage by demise. In this kind of mortgage, the property is usually transferred for a very long time, typically 3000 years, with the proviso that if the principal, loan and interest are paid by certain date, the term of year shall cease to have effect. Number 2, charge by way of legal mortgage. In this kind of mortgage, a deed is entered into between the parties stating that a charge has been made, but the period is not specified. The mortgagor remains the owner of the property, but the mortgagee substantial has rights like right of possession, right to sell the property, etc. On the other hand, an equitable mortgage is created when the requirements to create a mortgage are fulfilled, although the formalities to create a legal mortgage are not. The circumstances under which this can happen are: the parties have merely entered into an agreement to create a legal mortgage in the future over the asset in question, rather than formally creating such a mortgage. Another is, the property to be mortgaged is recognized only in equity, for example, an interest in a trust fund. Another one is, the property in question does not exist. The law of mortgage in the United Kingdom has changed over the years, and it was codified in the year of 1925. However, the classification of mortgages as it stands today is grossly complicated and makes standardized mortgage transactions impossible. The extreme complex classification makes it difficult for the common citizens to understand. In India, out of the 6 form of mortgages that exist, 5 are legal. The mortgage by way of demise is similar to the mortgage by conditional sale under the Transfer of Property Act 1882, where the sale becomes absolute when the time for repayment has lapsed and the mortgagee has exercised his right of foreclosure within the limitation period of 12 years. The charge by way of legal mortgage is similar to the English mortgage under the Transfer of Property Act 1882, wherein mortgagee acquires the right to possession as soon as the contract is executed, and if the mortgagor fails to pay the money by the due date, the mortgagee can sell the property without the permission of the court. One mortgage under the Act is equitable mortgage. Equitable mortgage exists under Section 58F of the Transfer of Property Act. It is the most prevalent form of mortgage in India. It is an oral transaction where mortgagor deposits the property's title deeds to the mortgagee and raises the money. In Gokuldas 1906, there is no formal conveyance, but even then there is a transfer of interest, thus making the transaction akin to a simple mortgage. The requirement of legal mortgage are not necessary. What is required is the delivery of the title deeds to the mortgagee with an interest to create a security their own. There is an essential distinction between an equitable mortgage as understood in English law and the mortgage by deposit of title deeds recognized under the Transfer of Property Act in India. Equitable mortgage in England encompasses a variety of circumstances, one of which is deposit of title deeds. Under Indian law, it is a narrower concept. Moreover, in England, an equitable mortgage can be created either by actual deposit of title deeds, in which case evidence is admissible to show the meaning of the deposit and the extent of the security created, or if there be no deposit of title deeds, then by a memorandum in writing purporting to create a security for money advanced. In either case, it does not operate as an actual conveyance, though it is enforceable in equity. Whereas, under the Transfer of Property Act, a mortgage by deposit of title deeds is one of the modes of creating a legal mortgage, where under there will be a transfer of interest in the property mortgage to the mortgagee. Therefore, in reality, an equitable mortgage is only creating a legal mortgage. This is why the distinction between the two has formally removed. Fundamentally, the Indian and English laws on mortgages are similar in numerous respects. But as seen above, equitable mortgage is a narrower concept in India, and in substance it is form of legal mortgage. So far as the legal mortgage is concerned, the law in the United Kingdom closely resembles the English mortgage and mortgage by conditional sale in India. The terms English mortgage has been used to refer to the general law governing mortgages in England, as opposed only to the particular kind of mortgage in India. In conclusion, we can say this module has dealt with the concept of English mortgage in detail, analyzing various aspects like its nature, ingredient differences from other kinds of mortgages and sale. An English mortgage is a very common form of mortgage in the country. It is a kind of transaction where the mortgagor absolutely transfers the property to the mortgagee with a proviso that he will retransfer it to the mortgagor after the payment of mortgage money. The basic essentials of an English mortgage are that the mortgagor must bind himself to repay the mortgage money on a certain date. The property mortgaged is transferred absolutely to the mortgagee, and the transfer is made subject to proviso that the mortgagee shall reconvey the property to the mortgagor upon payment by him of the mortgage money. The mortgagee can file a suit for the sale of property, but he does not have right of foreclosure. Dear viewers, this is all for the today. We will meet in the another discussion on law of property. Thank you.